दर्शकों, स्वागत है आपका अपने YouTube चैनल कानूनी चर्चा में। तो आज हम चर्चा करेंगे जो रिसेंट जजमेंट ऑफ दिल्ली हाई कोर्ट की है, जो हिंदू मैरिज एक्ट के नीचे सापिंडा रिलेशन पे जजमेंट आई है, तो उसकी कॉन्स्टिट्यूशनल वैलिडिटी सेक्शन 5 सब सेक्शन 5 रोमन ऑफ हिंदू मैरिज एक्ट की असेल की गई थी। तो उस पे ही जजमेंट है, उस पे काफी लंबी चौड़ी बात हुई है, डिस्कस किया गया है। हमारे इसमें प्रोविजन ऑफ हिंदू मैरिज एक्ट, इसमें कस्टम और जूसेस जो सेविंग्स क्लासेस हैं हिंदू मैरिज उसमें है। सपिंदा की डेफिनेशन को भी डिस्कस किया गया है कि व्हाट सपिंदा रिलेशनशिप क्या है, और आगे उसको सेक्शन 5 में जो मैरिजेस की वैलिडिटी की जो इंग्रेडिएंट्स हैं, रिक्वायरमेंट्स हैं अंडर हिंदू मैरिज एक्ट, उसकी बात की गई है। और सेक्शन 11 जो नल एंड वाइड मैरिज होती है इफ इट इज वायलेटिव ऑफ सेक्शन 5, उसकी भी बात है। और कॉन्स्टिट्यूशन के प्रोविजंस आर्टिकल 14, आर्टिकल 21, आर्टिकल 25 एंड आर्टिकल 20 9 भी डिस्कस किया गया है। और इसमें डिफरेंट जो पहले जजमेंट्स थी सुप्रीम कोर्ट ऑफ इंडिया की, वो भी डिस्कस हुई है कि कॉन्स्टिट्यूशनल वैलिडिटी किस एक्सटेंड तक जो जुरिस्डिक्शन एक्सरसाइज करते हुए एक हाई कोर्ट डिक्लेयर कर सकता है ऑन अल्ट्रा वायर देन द स्टैट्यूटरी प्रोविजन विच इज अल्ट्रा वायर द कॉन्स्टिट्यूशन, और जो उसके नीचे लेजिस्लेशन रूल्स बनाए हैं जहां रेगुलेशन है उसको के बारे में भी जो अल्ट्रा वायर उसमें भी कॉन्स्टिट्यूशनल वैलिडिटी उन रूल्स के उन रेगुलेशन की भी देखी जा सकती है। तो उस पे ये सारी बात है। तो हम आज ये जजमेंट जो मैंने दोबारा बता देता हूं आपको, जो 22 जनवरी 2024 किया, इसका टाइटल है नीतू ग्रोवर वर्सेस यूनियन ऑफ इंडिया। इसमें असेल किया गया था जो प्रोविजंस हैं सेक्शन 5 सब सेक्शन रोमन 5 ऑफ हिंदू मैरिज एक्ट दैट इज रिलेटेड टू स्पिंदा रिलेशन। तो मैरिज पहले क्या हुआ, इस केस के जो फैक्ट्स हैं ये ऐसे हैं कि पहले इनकी एक लिटिगेशन चली। जो इसका हस्बैंड था नीतू ग्रोवर का, उसने जे मैरिज जो हुई थी उसको असेल किया और डिक्लेयर जे मैरिज होगी नल्टीज इन द आइज ऑफ लॉ। सेक्शन 11 ऑब्वियसली अनवोक की होगी, जो उसका हस्बैंड था नीतू ग्रोवर का। और उसके बाद जो जजमेंट आई, उसके बाद ये जजमेंट जो है, ये जजमेंट जो आई है, ये जजमेंट मैं आपके दर्शकों के लिए बता देता हूं कि ये जजमेंट जो पहले आई थी, जे उसके बाद इसकी अपील हुई और एपीलेट कोर्ट जो डिवीजन बेंच था उसने भी इस जजमेंट को अपहेल्ड रखा। मीन के जजमेंट जो अनवोक किया था पहले वाली, जो उनकी आपस में एक विद रिगार्ड टू वैलिडिटी ऑफ द मैरिज एज पर हिंदू मैरिज एक्ट, जो उसके हस्बैंड ने किया था नीतू ग्रोवर के, उसमें सेक्शन 11 को वो करते हुए वो जो कॉम्पिटेंट कोर्ट थी, ऑब्वियसली डिस्ट्रिक्ट कोर्ट थी, उसने अपहेल्ड जो उसका रखा कि ये जो सपिंदा मैरिज रिलेशनशिप बेस्ड इनके जो रिलेशन है वो प्रूफ होते हैं। और फिर अपहेल्ड रही जो जजमेंट थी जिसके बेस पे जो नल एंड वाइड मैरिज डिक्लेयर हुई थी जो इन कपल के बीच में, वो डिवीजन बेंच ऑफ कंसर्न हाई कोर्ट ने इसको अपहेल्ड रखी थी। तो उसके बाद इन सारी चीजों को देखते हुए उसने ही हैज नाउ अडॉप्टेड अनदर राउंड ऑफ लिटिगेशन बाय assailing who by father, who has been defeated in the this earlier litigation. She approached the Hon'ble High Court of Delhi by way of a writ petition under Article 26 of Constitution of India, where she has assailed the provisions of Section 5, subsection Roman 5 of Hindu Marriage Act by taking the assistance of Article 21, Article 14, 20, Article 25 and Article 29. All. She has assailed that the sapinda relations which are existing, which has proved in that should be declared ultra by the Constitution, because there is a discrimination if the marriages which are being solemnized in southern India, particularly Karnataka and Tamil Nadu, are held valid on the basis of the customs prevailing among the particular community, tribes, and on this basis they are allowed to solemnize marriage between cousins. Why there is a discrimination in marriages of the people of the northern India? This is, she has said that Juse's custom as are applicable to the people of southern India the same should have been be considered as a provisions of law, and the people of North India be also allowed to solemnize marriage irrespective of they are being sapindas of each other. This is she has assailed she has taken assistance of particular Article 14. Why there is a discrimination? The Article 14 requires equality before law and equal protection of law. On that basis, she has assailed. Let me now read out some this important relevant aspects of this judgment. This judgment has delivered by the division bench of Delhi High Court. It was headed by acting Chief Justice and another judge accompanying him was Justice Manmeet Preetam Singh Arora. The Article 226 was invoked by the petitioner. Petitioner was Neetu Grover. She has assailed the provisions of Section 5, subsection 5 Roman of Hindu Marriage Act 1955. She has prayed for striking down of these provisions. Then Gagan Grover was her husband, who has contested this petition, opposed this petition, and after that he has said that first round of litigation in a which has held under Hindu Marriage Act, the marriage of the couple has already been declared nullities in the eyes of law as per Section 11, because it was violative of this marriage was violative of the provisions of Section 5, subsection subsection Roman 5 of Hindu Marriage Act. The definition of sapinda is available under Section 3 of 3G 1 and 2 of the Hindu Marriage Act. The sapinda, as the word it has meaning. Sapinda means same pinda, same jism. So let me explain what you mean by sapinda relationship. Sapinda relationship is two persons are to be said as pindas of each other if they are linear ascendant of each other if up to 5 degree towards father and 3 degree towards the mother. These are mother relationship 3 degree and father relationship is 5 degree. Both the degree where from the counting is to be started, it is inclusive and one has to go to up to 5 degree. The relationship on the linear side, ascending order, marriage cannot be solemnized between two sapinda. Sapinda mean having same pind, having same body. They are on 5 degree towards on the father's side and 3 degree on the mother's side. This is the definition section 3D subsection G of the this of Hindu Marriage Act. Now, initially the judgment came between Neetu Grover and her husband in a petition filed for declaring the marriage as nullity in the eyes of law before a concerned district court. It is dated 23rd of October 2017. Thereafter, this judgment was assailed before the division bench of Hon'ble High Court in a appeal. Division bench of Hon'ble High Court of the concerned High Court dismissed the appeal by its judgment dated 9th of October 2023. Thereafter, this petition assailing the sections, assailing the provisions of section 5 of Hindu Marriage Act was assailed by the wife Neetu Grover, who remained unsuccessful in the earlier litigation. Then this High Court of Delhi has taken assistance of one judgment, Dr. J.R. Thakur, while holding that a Parliament Act, a law, is always considered presumed as valid as per Constitution. Generally speaking, this is judgment of Dr. J.R. Thakur versus Union of India. I will read out the relevant para. The grounds on which the statute enacted by the Parliament cannot be declared unconstitutional or well settled as initiated in the judgment of Supreme Court in Dr. J.R. Thakur versus Union of India and others. There is a presumption. Further, it is added, there is a presumption in favor of the constitutionality of the statute enacted by the Parliament. Generally speaking, the validity of the constitutional validity of the a particular statute law of the Parliament is considered in favor of the law, unless and otherwise proved by the petitioner in an appropriate writ petition. This is on what grounds the constitutional validity of a particular statute, particular law can be assailed, or Hon'ble High Court or Hon'ble Supreme Court can consider the relevant grounds. I will read out those grounds which are held on this contravention of any fundamental right specified in Part 3rd of the Constitution on if the particular law is violative of fundamental rights, then the particular law or statute can be declared ultra vires the Constitution. There are other grounds also on that basis, on the basis of which the particular it will go long if I will repeat it. That those are all referred. Another judgment which Supreme Court has also, whenever constitutionality of a provision is challenged on the ground that it infringes a fundamental right, the direct and inevitable effect consequences of legislation has to be taken in account. The Supreme Court एक और जजमेंट सुप्रीम कोर्ट ऑफ इंडिया की इस जजमेंट में रेफर की डिवीजन बेंच ने while deciding the matter before them regarding the validity of constitutional validity of section 5. That this judgment is Namit Sharma versus Union of India, J 2013 की जजमेंट है, ये रेफर की है 1 SCC सुप्रीम कोर्ट केसेस 74 पेज दिया गया है. तो इसमें ये जजमेंट हुआ था, इसमें मैं शॉर्ट पढ़ दूंगा जो इसमें कंसीडर हुआ है पॉइंट. द कोर्ट शुड एक्सरसाइज जुडिशियल restraint while judging the constitutional validity of the statute or even that of a delegated legislation, and it is only when there is a clear violation of a constitutional provision beyond reasonable doubt. The ground for assailing a particular law should be such a consideration that it is beyond reasonable doubt. The particular ground on legal and factual side must be such a that it should be, if it is beyond reasonable doubt a particular provision of law is violative of the fundamental rights, on that ground on only the such provision can be declared as, such law can be declared as unconstitutional, otherwise not. This is also now in this judgment section 5 is lab upon, interpreted, and this bench has come to conclusion, no doubt, the section 5 of Hindu Marriage Act or any other provision of Hindu Marriage Act is subject to section 29 of there is a saving clauses under Hindu Marriage Act. Saving clause means if a petitioners, if it is proved that particular custom is existing with regard to a particular legal aspect or factual aspect, then it would supersede the enacted provisions of law. For example, if this couple would have proved, or particular Neetu Grover has proved, that there is a custom existing between the community of her husband and her, on the basis of marriage can be solemnized among sapindas, this among cousins or whosoever comes under definition of sapindas, the marriage can. But how the custom is to be proved? It is a custom should be not against a public policy. Next is, what is more requires, custom should be followed and practiced by the particular community, by the particular set of group of people from the time immemorial. And now it has taken the shape of a law. It has adopted as if it is a law. In this case, Neetu Grover no doubt has pleaded before the concerned competent court under Hindu Marriage Act that there is a custom existing, but she has not proved as per the earlier judgment. She has not succeeded in proof that there existed a custom which allows marriage among their community among sapindas. A sapinda can solemnize marriage. So there she could not succeed, and this is also came in the had she proved that such a custom is existing, it is adopted, followed from a long time. It is not against the public policy, or and it has taken now the form of a law. It is being adopted as a law, followed as a law. So obviously, her marriage, this custom would have superseded the relevant provisions of Section 5, subsection 5, but she could not have succeeded. This is also considered in this judgment, and finally this judgment is now the parties are not sapindas of each other unless the custom or juices governing each of them permits of marriage between the two. I may repeat again that only those marriages survives among Samitas if the custom, juices in particular community allows such type of marriages. This now another question was raised by the Neetu Grover, its counsel before that right to marriage, solemnize, it should be considered as absolute right. It should have a constitutional merit. But the bench which was dealing with this petition has held that the marriage among Hindu is considered as a sacrament. It involves religion, culture, and and relevant juices and practices, no doubt. But they had taken assistance of a judgment of Supriyo, alias Supriya Chakravarti, and another versus Union of India. It has held in that judgment, in this judgment of Supriyo, alias Supriya Chakravarti, where an Hon'ble judge has held that right to marriage is a statutory right. No doubt, because under Hindu Marriage Act, if the particular couple is Hindu, as defined as under Hindu Marriage Act, so they have a statutory right, but it is subject to state's regulation. But it is not absolute right of marriage. The finding of the said binding opinion, which are relevant to the challenge raised in the writ petition, read as under: there is no unqualified right to marriage granted by the Constitution that qualifies it as a fundamental freedom. With respect to this, I agree with the opinion of Justice but will supplement it with some additional. So this judgment, the judges recorded their own finding, one of the judge, and he has supported the finding of his brother judge, Justice Butt, and simultaneously added its own for the this is the right to marriage is a statutory right, and to the extent it is demonstrable a right flowing from a legal enforceable customary practice. In exercise such a right, statutory or customary, the state is bound to extend the protection of law to the individual so that they can exercise their choices without fear and coercion. In this, obviously, he has also recognized that customs and uses should also be allowed to be followed, practiced, if being adopted from time immemorial by a particular entity recognized as a law. This is also this marriage as a social institution and status of the right to marry. This is all these things have been considered in this judgment. Even when our own constitution state attempted codification and reforms, it left room for customary practice to coexist. No doubt, Hindu law was codified. This particular related to marriage as a Hindu Marriage Act, but there is a saving clause. There is a saving section 29 IRF on which allows marriages which are allowed by customs and usages being practiced among particular communities. There is an exception to the provisions of law can be superseded by the customary law, which says if existing. This is held in this. Finally, in this judgment, court has held that no ground is made out, particularly a ground which touches the constitutional validity, which is such a extraordinary and exists beyond reasonable doubt for declaring a particular this section provisions of law beyond reasonable doubt as violative of constitutional provisions of law. No, this court is unable, this is now crux of the judgment is finding crux of the judgment. Now I'm going to read. This court, division bench, Hon'ble High Court of Delhi has had, this court is unable to accept the contention of the petitioner. Petitioner is Neetu Grover. That impugned section is violative of Article 14, Section 5, Subsection 5, Roman of Hindu Marriage Act. As the exception impugned section is only for marriages between the persons on the basis of customs having force of law, which requires stringent proof, and its existence is to be adjudicated upon by the court of law. The petitioner was unable to prove. Now they have taken the assistance of the factual aspect decided in another judgment, in which this judgment has delivered delivered by the concerned division bench of the High Court and Hindu Marriage Act, where her husband has assailed the validity of the marriage being between two sapindas. The petitioner was unable to prove the existence. Had she proved, I am repeat again, had she proved that among their community there is a custom which allows marriages between cousins, between sapindas, then she would have succeeded, but she could not prove such a custom existing among their existing. The petitioner was unable to prove existence of custom in the facts of our case and has relied upon the consent of the parents, which cannot take the place of custom. The court therefore finds no merit in challenge to Section 5th of the Hindu Marriage Act in the present interpretation. So finally उन्होंने कहा कि no ground is existing. There is nothing which has been projected by the petitioner which can be made a ground for declaring the provisions of Section 5, subsection 5 Roman of Hindu Marriage Act as unconstitutional. With respect to relief sought at prayer, the same are sought specifically against Gagan Grover and his family members who are not party to this petition and therefore cannot be granted by this ground court on this ground alone. These are also needless to state that the petitioner will be at liberty to initiate appropriate legal proceedings against Mr. Gagan Grover before an appropriate. The matter kept open. If she has another remedy available, if it is appropriate remedy in accordance with the law available for it, appellate form, appellate court, this appropriate court, she can avail that in accordance with law against her husband or his family members in the appropriate petition in accordance with law. But she failed in this petition, wherein she has assailed the constitutional validity of the provisions of section 5, subsection 5 Roman of Hindu Marriage Act. The crux of this all discussion, the institution of marriage, particularly concept of marriage, idea of marriage between the Hindus, is that marriages should be solemnized between two Hindus strictly in accordance with section 5. Section 5, besides other things, deals with age of the couple who are going to be entered into a marriage. Next is 18 and 21. In case of male, it is 21. In case of female, it is 18. I am going to add more. Next is nobody, the proposed bride or bridegroom should have an earlier husband or wife. Suppose prior existing while having marriage. Next is with regard to this sapindas relation, and one more is prohibitory degree. We will delve upon these other grounds subsequently. Today I wanted to explain, to make a reference, to advise the people that while entering into marriage, the couple, his family, should be careful that marriage should not be solemnized, which is violative of the relevant provisions of law. It should be solemnized in accordance with, there is a section 5. The section 7 is also there, which relates to ceremonies to be adopted, to be followed, to be conducted, undertaken at the time of solemnization of marriage. If such type of marriage is not recognized by court of laws, which is among two sapindas, which is among the people, the relationship of prohibitory degrees. This is why this is being done. This in order to keep the sanctity of the relationship, because Indian society, Indian culture, that is on basis of the ethnicity which we are following, we are adopting, on the basis of the religious practices that recognized that there should not be marriage, in particular among Hindus, between cousins, lineal descendants. I repeat again, 5 degrees from father's side and 3 degrees from mother's side. On the lineal ascendant side, or the people who comes in the relationship, such relationships. So that is today's discussion, today's decodification of the judgment of the Hon'ble Court of Delhi relating to section 5, subsection 5 of Hindu Marriage Act, the constitutional validity of which was assailed by the petitioner Neetu under Article 226 of Hindu Marriage Act. तो ये मेरा आज का जो विषय था बहुत इम्पोर्टेंट था, खासकर जो हमारे लॉ स्टूडेंट्स हैं, जो हमारे लॉयर्स हैं, जजेस हैं, इस बात को समझो। और ये जजमेंट्स जो हैं ये बहुत इम्पोर्टेंट होती है। और मैं ये एक एडवाइस करूंगा अपने जो लॉ स्टूडेंट्स हैं, जजेस हैं, लॉयर्स को, इसको डीपली पढ़ना चाहिए। इसमें आपको कितनी चीजों, इस जजमेंट में ही कितनी चीजों का आपको आइडिया हो जाएगा कि कॉन्स्टिट्यूशनल वैलिडिटी किन केसेस में, किन ग्राउंड्स पे हम दे सकते हैं जी, और क्या होती है, कौन सी लेजिस्लेशन होती है जिसमें ये अनकॉन्स्टिट्यूशनल हो सकती है, स्टैट्यूटरी प्रोविजंस क्या है, हिंदू मैरिज, ये सारा एक लंबा चौड़ा विषय है। तो मुझे दीजिए इजाजत। थैंक यू वेरी मच। ये जो मेरा चैनल है जो फ्री ऑफ कॉस्ट है, इसमें कोई, तो इस चैनल को आप देखो, अगर अच्छा लगे एपिसोड तो इसको शेयर करो, लाइक करो, और मेरा चैनल कानूनी चर्चा को सब्सक्राइब करो, ताकि आने वाले जो भी एपिसोड हो जो आपको डायरेक्टली अवेलेबल हो जाए। थैंक यू वेरी मच।